It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. I've been doing my thing for a minute since staying due to my brain. Get exchanged for the lyrics ordained. Like a minister, I pray for my spirit, don't do it in vain. Y'all call it the game, it's a scrimmage. I got more flows, I'm king like a corso. My legend was foretold, I'm saving the poor souls. I came from the struggle, my home was foreclosed. Injecting myself to the population like hormones, but it's straight as a torso. And it's all no cap, I stay kicking to my base, that's facts. I got the world on my back. Black royalty, raised on fam loyalty. All I do is shine on screens, my skin oily. Swag on 100, becoming a gold. Nothing but dope, running the show, I'm one with the glow. Yeah, whack artists, they come and they go. I just be summoning growth, learning to broaden my scope. Yeah. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well this evening. Now, if y'all can remember, man, Lil Rod, aka Rodney Jones, aka a former music producer who, well, he's still a music producer, but a music producer who formerly worked with Diddy on the Love album. Remember, he came out and he set the internet ablaze, the world ablaze, with his allegations against Diddy of trafficking, misconduct, harassment, all these different things. And this is where a lot of the man-on-man allegations really began to ramp up, right? And he also said that he was owed royalties off of the Love album, that he was taken advantage of in not only physically, but financially. He put out a RICO on Diddy, all of these different things. And I've been waiting for a minute to see what the judge was going to rule on this thing, because it's been out for over a year. Now, this is not anything final. This is just an update. However, it looks like, 5 out of 9 claims against Diddy have been tossed. There's still some remaining, but some people view this as a win for Diddy, but the lawsuit still survives. So it hasn't been tossed out. It hasn't been, taken from the record or anything like that. It hasn't been ruled out or dismissed, but some of the claims in his lawsuit have been knocked out the sky. We'll say that much, okay? So let's go ahead and pull this up. All right, Rodney Jones lawsuit versus Diddy. Judge tosses majority of claims. Scolds his lawyer, as in Lil Rod. They say Diddy won a small victory in court today when the judge tossed a majority of claims against him in a lawsuit filed by a former music producer accusing him of assault. According to new legal documents obtained by TMZ, the judge dismissed 5 of the 9 claims Rodney Jones made against Diddy, including RICO claims, infliction of emotional distress, and breach of contract claims. The court also dismissed a Trafficking Victims Protection Act claim against Diddy's company, Combs Global. Rodney's lawyer, Tyrone Blackburn, even got dressed down by the judge, who warned him that his legal filings in the case have not been up to par. Now, this is one of the things that has also been a conversation surrounding this, is Tyrone Blackburn, right? He's been taking on a lot of high-profile cases, but he hasn't necessarily been having the most success. It just seems like he's been trying to attach himself to these celebrity lawsuits and things of that nature, but his reputation doesn't seem to be all that credible. He has won some, but he's taking some big losses as well. In one example, the judge pointed to Blackburn's filing, seemingly not understanding that Diddy is presumed innocent in a separate grand jury indictment on criminal charges. TMZ broke the stories. Jones sued Diddy back in February 2024, and Diddy ripped the suit as a money grab dressed up as a trafficking and RICO conspiracy. The case is still moving forward despite 5 of the 9 claims being tossed, and serious claims of SA against Diddy were not dismissed. It will be interesting to see if these claims ever make it to trial. Rodney's lawyer tells TMZ, yeah, a win is a win. Playtime is over. We look forward to discovery. I hope the defendants are ready. So they're saying with the remaining 4 counts that they are able to move forward with, they have sufficient discovery. That is yet to be seen. And that's just the TMZ abridged version. I actually have access to the full ruling from the judge. It is pretty lengthy. I'm hoping I could get through it in a timely fashion. But let's just go ahead and see what the judge has to say. All right, Rodney Jones versus Sean Combs. This is opinion in order of J. Paul Etkin, District Judge. Plaintiff brings this suit alleging inter alia violations of the Racketeer Influenced and Corrupt Organizations Act and the Trafficking Victims Protection Act of 2000, also known as TVPA. Okay, based on defendant Sean Combs' alleged sexual misconduct before the court are motions to dismiss filed by Combs, his business enterprise, and Christina Coram, who is his business partner. For the reasons that follow, business partner of Diddy. For the reasons that follow, the motions are granted in part and denied in part. Okay, so then they get into the background. Plaintiff Rodney Jones brought this action against Sean Combs, asserting a variety of claims based on Combs' alleged history of SA and human trafficking. Named alongside Combs are Combs' son, Justin Dior Combs, the actor Cuba Gooding Jr., Combs' chief of staff, Christina Coram, his record label Love Records, his company Combs Global Enterprises, and an unidentified female described as Young Miami's cousin, who allegedly tried to force herself upon him and try to as his D, to which he declined. Okay, that's according to his lawsuit. The second amended complaint asserts 17 causes of action, of which 14 remain. These include 2 federal claims, a RICO claim against Combs, Justin, Combs Global and Love Records, and a TVPA claim against Combs, Justin, Coram, and Combs Global, and various state law claims against Combs, Gooding, Jane Doe 1, and Love Records for breach of contract, SA, premises liability, and infliction of emotional distress. The following facts were taken from Jones' complaint and presumed true for purposes of this opinion. Jones' claims stem from his work between September 2022 and September 2023 as a producer on Combs' Love album. During this time, Jones lived with Mr. Combs for months, spending holidays, birthdays, and missing major family events. Jones resided at Mr. Combs' residences in Los Angeles, California, and Miami, Florida, spent several weeks on a yacht rented by Mr. Combs in the U.S. Virgin Islands and St. Bartholomew, and made several trips with Mr. Combs to New York City. Jones alleges that disturbing incidents began nearly immediately after he joined Combs' team. On approximately September 12, 2022, Jones alleges that he was present at Chalice Recording Studio in Los Angeles when Combs and Justin shot an unidentified man, and that Jones provided first aid services to the victim. They also had screenshots of bloody bathroom of this incident, right? They say that when the LAPD came, they acted like it was business as usual, didn't act like anything was strange, although the blood was still all over the floor and the toilet, right? They then proceeded to show a news clipping where the news said that this shooting happened in the vicinity up the block rather than the studio. So he says that Diddy used his resources to misdirect this shooting and say that it happened elsewhere rather than in the actual studio. These are Jones or Lil Rod's allegations. And he had news clippings to verify what he said. Okay. Jones also alleges that he and other witnesses were pressured to hide the shooting from the police and the public. Okay. He also says that one of the officers that showed up is on Diddy's payroll and basically told them to hush about everything. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching of his anus by Mr. Combs. Oh, wow. And that he was forced to work in Mr. Combs' bathroom. What? I didn't know about all that. This must have been added. This must be an amended complaint. Forced to work in Mr. Combs' bathroom as Mr. Combs walked around naked and showered. Combs allegedly used access to powerful individuals in the music industry, including producer Steve Aaron Jordan, aka Stevie J, to groom and entice Mr. Jones to engage in homosexual acts, including by sharing a video with Jones of who he claims was Stevie J anally entering another man. Now, there was a clipping of that, but that person was not Stevie J. I will say that. In addition, Combs promised to make sure that Mr. Jones wins Producer of the Year at the Grammys if he engaged in these man-on-man acts. Quorum was allegedly aware of and attempted to downplay Combs' misconduct and work with Mr. Combs to groom Jones into accepting a man-on-man relationship. Jones alleges that other individuals in Combs' orbit committed this sexual misconduct against him as well. For example, on Thanksgiving Day 2022, that's just crazy, man. They trying to give you some stuffing on Turkey Day. That's crazy. Jones alleges that he was SA'd by Jane Doe while he was staying in Combs' house in Miami. Jones also alleges that he was assaulted by Cuba Gooding when Combs left them alone together in a makeshift studio on his yacht, which he did have photos of himself and Cuba Gooding Jr. in the makeshift studio, in which Cuba Gooding did have his arms wrapped around him very closely, and one of his hands did look like they could have been on his thigh. Cuba Gooding says, man, that's bullshit. Y'all can make your determination. During his time working for Combs, Jones was transported from California to New York, Florida, St. Bartholomew, and the United States Virgin Islands. And while accompanying Combs to these various locations, Jones was allegedly coerced into participating in commercial sex acts against his will. Combs allegedly forced Jones to solicit sex workers and perform sex acts. And I believe they said that he would give him a bad boy hat to wear when he had to go out to go scout these pros. And the women would know by the bad boy hat, okay, Diddy's coming for us, okay? And to bring them back to Combs' home. On approximately February 2nd, 2023, Jones believes Mr. Combs drugged him and recalls waking up naked, dizzy, and confused in bed with two S-workers and Mr. Combs. On approximately July 2nd, 2023, Jones alleges that he was present while Combs solicited these workers, some of whom were underage, he claims, and forced them to drink liquor laced with narcotic drugs. When Jones attempted to leave, Combs allegedly forced him to stay, including taking Mr. Jones' car keys to prevent him from leaving. Jones alleges that Combs then forced him to drink the laced liquor, after which Jones began feeling lightheaded and recalls passing out and waking up at 4 a.m. the following morning naked with a sex worker sleeping next to him. Jones alleges that Quorum was intimately involved in Combs' misconduct and at times requested that Jones participate in transporting Combs' drogas and ordering S-workers on Combs' behalf. Remember, the hat. Jones states that Combs used his power and influence to intimidate and force Jones into performing these actions. This included promising Jones a Grammy for Producer of the Year, although he had no power to promise such a thing, $250,000 to purchase all the instruments he wanted, $250,000? You was about to buy that man a whole studio. Ownership of Combs' $20 million property. I don't understand how he could even begin to believe he was going to let you own his home, the same home that's in his mama name in Miami, and access to record access to record label executives, as well as threatening Mr. Jones with physical harm. Of course, Rodney didn't know all these things. He found out. The threats took various forms, including threatening to eat Mr. Jones' face. This is a quote from his lawsuit. Informing Jones that Combs was willing to kill his own mama, so he wouldn't think twice about harming Mr. Jones on some Bishop and Juice. You less of a man than me. So when I say, bah, so be it. Better get the wind behind your back, partner. Displaying his guns in front of Jones and bragging about getting away with shooting niggas. And telling Jones that Combs' head of security had the power to make people and problems disappear. During the production of the Love album, Combs allegedly required his employees to consume alcohol and dismiss them if they refused, further stoking Jones' fear of what could happen to him if he told Mr. Combs no. I'd rather be dismissed than be disengaged in some shit that I don't want to. And I don't mean disengaged literally. I mean disengaged. In addition to Jones' various claims of sexual misconduct, he also alleges that he was not compensated for his time living with Mr. Combs or for the songs Jones produced. Jones claims that this violated the terms under which he was recruited to work on the Love album, which included $20,000 up front for each song he produced, 4 royalty points, credit as a producer, and for each instrument he played on the songs, and retention of publishing rights. When Jones confronted Combs about this, Combs allegedly offered him $29,000 in total compensation, which Jones refused. Now, some people might say, well, if he said $20,000 but then he offered you 29, that should be fair. No, 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 no. Remember, 20,000 for each song. Lil Rod claims that he produced on damn near half the album. He was supposed to get 4 royalty points, which in the music business is very significant because that would be toward the actual sale of the album. He would get credit as a producer, and he would get credit for each instrument he played, and he would retain his publishing, which Diddy is very notorious for taking from people, right? Then he says Diddy offered him $29,000, period. Basically reneging on his promise and said, I give you $29K, bitch. Take it or leave it. Jones brought this action on February 26, 2024, and filed the operative claim on April 12, 2024. Jones voluntarily dismissed his claims against certain, defendants on May 14, 2024. I believe that included UMG and Sony and other people like that, the bigwigs of the industry. And the court thereafter denied a request by those defendants to impose sanctions on Jones and his counsel. Sean Combs, Combs Global Enterprise, Love Records, all these niggas moved to dismiss the operative complaint on August 26, 2024 and filed a supporting memorandum of law. Quorum moved to join that motion on the same day. Jones opposed the motion on September 30th, and the Combs defendants replied on October 18, 2024. Quorum also requested permission to join in on the Combs defendant reply. Quorum did not file her own motion or memorandum of law, although she is an individual defendant rather than wrapped up in just Diddy. So she's not necessarily taking all of the necessary precautions to protect herself. She's just joining in on what Diddy got going on, which doesn't look good to me. Here we have a warning to counsel. Before addressing the substance of Jones' claims, the court finds it necessary to issue a warning to his counsel, Tyrone Blackburn. Previously, the court declined to impose sanctions on Blackburn related to the admittedly false claims he filed on behalf of Jones against Universal Music Group and associated defendants. While Blackburn may have acted incompetently at times, the court determined that there was insufficient evidence to conclude that he had engaged in a pattern of bad faith. Blackburn also has a pending referral to the Southern District's disciplinary committee for his repeated failure to investigate basic elements of his cases. Okay? And they say cases. So this is not the only time that Tyrone Blackburn has been under scrutiny by, legal standard. They say in light of this, the court finds much of Blackburn's conduct regarding defendant's motion to dismiss to be unsettling. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. For example, in urging the court to consider a grand jury indictment of Combs on related criminal charges, Blackburn writes, as evidenced by U.S. Attorney Williams' press conference in the grand jury indictment, defendant Sean Combs and the Combs RICO enterprise are presumed guilty of being a RICO criminal organization, which we know you don't presume anyone guilty. You're innocent until proven. So as a defendant of law, you should know that. That any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. Then, rather than focusing on the claims pleaded in this lawsuit, Blackburn writes that it is evident from the multiple civil lawsuits and the 14-page indictment that kind of sexually deviant monster Sean Combs is. Both the operative complaint and Blackburn's opposition brief are all full of similar irrelevant insults, misstatements, and exaggerations. In response to defense counsel's understandable objections, Blackburn hurls schoolyard taunts at them, writing that it is clear that defense counsel are obsessed with me. Oh no, not putting yourself in there. You sounding like Busby. You sounding like a Tyrone Busby, dog. And although initially flattering, their obsession has become creepy. The court has inherent authority to sanction Blackburn should he act in bad faith, vexatiously, wantonly, or for oppressive reasons. While the court will not hold Blackburn's antics against Jones at this point, it warns Blackburn that further misconduct may lead to sanctions or to referral for discipline. Blackburn has a professional obligation both to the court and his client to state the law accurately, to collaborate in a respectful and constructive manner with fellow lawyers, and to allow this litigation to proceed efficiently. The court will not hesitate to enforce this obligation moving forward. So this is basically your last motherfucking warning, dog. Now, here we are with RICO allegations, right? Which ultimately the judge has thrown out. They say Jones' first federal claims as for violations of RICO, which makes it unlawful to deploy the proceedings of racketeering activity in any enterprise. Okay? To establish a RICO claim a plaintiff must show a violation of the statute and injury to business or property and causation. Defendants urge that Jones has not pleaded an injury to business or property caused by such a violation and therefore lacks standing under the act. Now, what I find interesting is how he couldn't show that due to him suing Diddy for these acts that he's been blackballed by the industry or something to that effect. But of course, blackball is typically looked upon as myth rather than truth. So I guess it is a little bit hard to prove. According to defendants, the sole injury to business or property alleged is the purported non-payment for services Jones claims he performed on the Love album, but Jones alleges no causal connection between this injury and any purported RICO predicate act. Jones does not respond to this argument. Damn, y'all didn't even respond to it? No wonder it got tossed. A compensable injury to business or property encompasses specific pecuniary losses. Oh, they using WWE as an example. Shit. Let's go past the examples. A plaintiff only has standing if and only it can recover to the extent that he has been injured in the business or property by the conduct constituting the violation. Both factual and proximate causation are required. The former is assessed under the familiar but for standard, while the latter requires that the RICO pattern or acts be a substantial factor in the sequence of responsible causation and that the injury is reasonably foreseeable or anticipated as a natural consequence. Okay. Applying the principles of the operative complaint precludes most of Jones' alleged injuries from supporting RICO's standing, including his claims of trauma, mental health problems, emotional pain and suffering, and embarrassment and humiliation. Nor can Jones base standing on secondary economic consequences of these personal injuries, such as difficulty finding employment. Oh, wow. Defendants are therefore correct that the only compensable injury that Jones pleads is defendant's non-payment for his work on the Love album. Defendants are also correct that their alleged refusal to honor the contract with Jones is not itself a RICO predicate act, even if the contract breach resulted from Jones' refusal to participate in Combs' alleged racketeering scheme. Now that I find to be very interesting. They say that even if you refuse to participate in Diddy's alleged racketeering scheme and then they breach the contract or say, I refuse to pay you, the judge says that it doesn't hold up as RICO. Interesting. The question then is whether any of the other alleged RICO predicates or the pattern of racketeering activity as a whole caused defendant's failure to pay Jones under the putative contract. The court cannot identify any such causal link. Defendants' alleged sex, drug, and gun trafficking activities, the vast majority of the predicate acts pleaded in the operative complaint, did not foreseeably or naturally preclude defendants from honoring their recording contract with Jones. Indeed, Jones' own theory of why he felt pressured to go along with Combs' sex, drug, and firearm-related misconduct for so long is that he believed he would be compensated not only under his contract, but in additional benefits like securing Grammy Awards, purchasing $20 million homes, participating on future projects, $250,000 cash payments, and meeting influential music industry executives. Oh, so basically they saying you thought that you was going to get all of these benefits, therefore you would have continued as you did. Damn. So they saying you can't take no more high ground because you thought you was going to get all these benefits in return for fucking around. Look like you found out. Nor can Jones base standing on the notion that defendants fraudulently induced him to enter the contract in the first place. Damn. They said nobody made you sign that shit. Nobody said you had to do this. Judge being a little bit too real for me. Because RICO compensates only for injury to business or property. A victim who is induced to part with his property by the misrepresentation of a fraudster is generally not entitled to benefit of the bargain damages, meaning recovery of what the fraudster promised as opposed to the property the victim lost. Interesting. Jones also fails to plead any facts from which the court could infer that defendants never intended to perform under the contract in the first place. Defendants sought to acquire wire transfers and cash payments to utilize their talents and labor to produce music and other tangible goods and services without full compensation. Wow. And Jones identifies no specific examples of fraud occurring after the formation of his contract that reduced the value of the contract or caused defendants' failure to pay. While Jones repeats the word fraud throughout the operative complaint, he appears to often do so as a synonym for illegal and does not identify any specific misrepresentations related to his contract. So they're saying Diddy didn't commit any fraud against you for the most part, or at least that's how I'm processing it. They're saying that yeah, it may be illegal or maybe he didn't pay you, but is it fraud? In sum, whether or not Jones has adequately alleged the existence of a RICO enterprise, he has not tied the activities of that enterprise to defendant's breach of contract or any other business or property harm incurred by Jones. It also bears reiterating that Jones fails to address any of these arguments in his opposition brief. That's where y'all fucked up. Y'all been so busy trying to make this a scandal that y'all ain't been properly processing your paperwork. And while the court prefers to decide issues on the merits, it should not be necessary to root around a 402 paragraph complaint to contrive novel arguments on Jones' behalf. So they say y'all did a 402 paragraph complaint, but now y'all ain't submitting your proper paperwork. Get your shit together, brother. So they say here, what is this? The court may and generally will deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. They give you all these examples. Jones' efforts to convert a garden variety breach of contract case into a RICO suit therefore fails. Okay, so this is the real crux of the issue. They say this should be a simple breach of contract case, but you tried to turn it into a RICO. And they say you failed because you ain't been answering properly. And his RICO claims are dismissed as to the Combs defendants and quorum. So all the RICO here goes out. That doesn't mean that the RICO goes out in Diddy's federal case, but in this lawsuit, RICO will not stand. This is for the TVPA. Of course, this is I think transporting, prostitution and all this stuff. Jones next asserts TVPA claims against Combs, Quorum, and Combs Global. The TVPA makes it unlawful to recruit, entice, harbor, transport, obtain, maintain, patronize, or solicit by any means a person, knowing or in reckless disregard of the fact that means of force, threats of force, fraud, coercion, or any combination of such means will be used to cause the person to engage in a commercial sex act. The statute does not define terms like entice or recruit, so courts have given those terms their ordinary meaning, holding that they cover conduct ranging from attracting a victim by offering something that arouses hope or desire to somehow securing the services of a victim. The term coercion is defined as A, threats of serious harm or to physical restraint against any person, B, any scheme, plan, or pattern intended to cause a person to believe that failure to perform an act will result in serious harm or physical restraint against any person, or C, the abuse or threatened abuse of law or the legal process. The term commercial sex act means any sex act on account of which anything of value is given to or received by any person. And the term serious harm means that which would compel a reasonable person of the same background and in the same circumstance to perform or to continue performing commercial sexual activity in order to avoid incurring that harm. The jurisdictional component of the act is satisfied by a de minimis effect on interstate commerce, including such minor conduct as the use of cell phones and the internet. The TVPA provides for civil actions by the victim against the perpetrator or whoever knowingly benefits or attempts to or conspires to benefit financially or by receiving anything of value, participation in a venture that which that person knew or should have known has engaged in an act in violation of this chapter. Courts have counseled that the TVPA is to be given broad interpretation in light of its remedial purpose and the broad, expansive language it employs. Given the TVPA's breadth, Jones has adequately pleaded violations as to Combs on numerous occasions. Combs allegedly recruited or enticed Jones to solicit and perform sex acts with commercial sex workers, as well as transported Jones across state and international borders in order to do so. Combs allegedly secured Jones' compliance with his request both by promising economic benefits that never materialized and by threatening Jones with physical restraint and harm. Because the operative complaint is lengthy and includes multiple examples of conduct adequate to ground a TVPA claim, the court here lists only a representative sample. So they say it's too much to name, but we'll give you a little. On July 2nd, 2023, Jones, having traveled from his home in New York to Combs' home in California, he was allegedly asked by Combs to solicit female sex workers on Combs' behalf, including multiple individuals under the age of 18. Jesus Christ. When Jones expressed his discomfort with the situation and attempted to leave, Combs forced him to stay. This included confiscating Jones' car keys to physically prevent him from leaving. Combs then pressured Jones into drinking ecstasy-laced liquor, after which Jones recalls passing out and waking up in the bed with a sex worker. Jones has thus alleged recruitment to participate in commercial sex acts along with physical restraint and a threat of force resulting from Combs seizing. Am I moving? Hold on, y'all. All right, y'all, we back. In addition to drugging and physically restraining Jones, Combs also allegedly used verbal threats of force and fraudulent promises to induce Jones to solicit and have sex with commercial sex workers at my... we already got there. To secure Jones' compliance, Combs allegedly threatened to eat Mr. Jones' face, informed Jones that Combs was willing to kill his own mother so he wouldn't think twice about harming Mr. Jones, displayed his guns in front of Jones and bragged about getting away with shooting people, and told Jones that Combs' head of security had the power to make people and problems disappear. Combs also promised Jones benefits such as access to record label executives and funds to purchase all the instruments he wanted. Courts have found the making of similar promises, combined with their repudiation and non-performance after the desired sex acts have occurred, to constitute fraud for purposes of TVPA liability. So this does constitute fraud. Okay. The TVPA extends to enticement of victims by means of fraudulent promises of career advancement for the purpose of engaging them in consensual or, as alleged here, non-consensual sexual activity. While some of Combs' promises, such as ownership of a $20 million mansion, were perhaps too ludicrous to be taken seriously, others, such as access to power players in the music business and help purchasing equipment, were not. So they say that this is enough for the TVPA, which is transporting, prostitution, and all of this stuff, but it's not enough for RICO, okay? The court therefore concludes that Jones has adequately pleaded that on multiple occasions between September 2022 and September 2023, Combs recruited or enticed Jones to participate in commercial sex acts that Combs knew would involve threats of force or fraud. Finally, Jones adequately alleges that direct sexual assaults committed by Combs himself were commercial for purposes of the TVPA. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant unsolicited and unauthorized groping and touching. Jones alleges that in order to entice him to accept this unwanted conduct, Combs used access to successful music producers and promised to make sure that Mr. Jones won Producer of the Year at the Grammys for his work on the Love album, which, again, how the hell you gonna promise some shit like that? Unless he felt like he had some people under his thumb that would make that happen. But I mean, come on, man. Anyway, they say, as in the Harvey Weinstein cases, such promises constitute anything of value and are sufficient to transform the resulting sex acts into commercial ones. Defendants make two main arguments. First, defendants argue that Combs' threats and promises were so outlandish that they fail to meet the general requirement that pleadings be plausible. Of course, the defendants would be Diddy's lawyers, as well as the TVPA specific requirement that coercion be assessed from the standpoint of a reasonable person in the same circumstances. The court disagrees. It's not just what Combs said that supports an inference of fraud. The context and history of Combs and Jones' professional relationship imports a degree of legitimacy of materiality to the statements. Combs is not only a successful artist and executive with extensive ties to the industry, but has a track record of winning precisely the awards that he promised to Jones. Combs also has a long history of public allegations of violence, specific instances of which Jones allegedly witnessed firsthand. Now, what I will say about this producer of the year thing, I feel like that could be something said in jest in the studio. I gotta be honest. Where it's like, man, you do this for me. If we could really get this thing popping, you might fucking win producer of the year, Playboy. Just fuck with me. Stick with me. I'ma get you there. You know what I'm saying? It's not necessarily a promise, but it's more of an assertion that I can get you to where you want to go. I could see that being a thing, but for that to be like a real promise, I don't know. Some people are gonna say differently, but that's just how I see it. Anyway, Combs has a long history of public allegations of violence, specific instances of which Jones allegedly witnessed firsthand. Given this context, it was not unreasonable as a matter of law to take Combs' promises and threats at face value. And while Jones' counsel may be unfortunately inclined to use incendiary and salacious language, it is not facially absurd or irrational that a powerful artist and producer would engage in sexual coercion of the sort alleged here. Jones' allegations also need only be plausible, not probable, at this stage in the proceedings. So they only need to say it could happen, right? And not to the degree of what percentage the probability is at this stage, which at the next stage, the judge could say, all right, we still not fucking with this. But at this point, they're saying we're allowing it to move forward based on plausibility. Okay. These are examples. Second, defendants argue that Jones fails to provide dates for some of Combs' threats and promises, and that Jones fails to link those threats and promises to specific sex acts. Defendant therefore argue that because no specific threat is casually linked to any sex act, Jones fails to establish TVPA liability. Setting aside the specific dated allegations of Combs drugging and restraining Jones to secure his compliance, defendants are correct that Jones does not connect most of Combs' verbal threats to specific sex acts on specific dates. However, while a casual relationship is required, Jones' allegations suffice to plead one here. As in the Weinstein cases, the complaint must be read as a whole, not deconstructed and parsed sentence by sentence. Here, Jones provides a bounded time frame within which Combs' conduct occurred, namely the year that Jones spent living and traveling with Combs. Jones also alleges that throughout that year, he was the victim of unwanted sexual advances from Combs, along with an ongoing campaign to groom Jones into accepting such advances. Jones provides specific and dated examples of Combs making threats of violence and alleges that such threats were part of the grooming process. The complaint also specifies at least some occasions on which Combs made the quid pro quo nature of his promises clear. Taken together and with all inferences drawn in Jones' favor, these allegations support an overall inference that Combs used a combination of threats and promises to secure compliance with his requests, and that those requests included participation in numerous commercial sex acts. Federal pleading standards do not require more precision at this stage in the litigation, but moving forward, they're going to have to be a little bit more accurate in what it is that they're saying, right? Now, as it relates to Miss Coram, according to Jones, Coram was Combs' chief of staff and was aware of Combs' sexual misconduct, including his unwanted groping and touching of Jones. Jones also alleges that he expressed his discomfort with Combs' behavior to Coram and that Coram refused to intervene. She did, as according to his lawsuit, I remember reading that, justifying Combs' conduct by saying that Sean will be Sean, as in, hey, you're going to have to get used to it because that's how it is. Like on some boys will be boys type shit. And that it was just Combs' way of showing that he likes you. Coram also allegedly requested that Jones order sex workers for Combs on at least one occasion. Okay, so Lil Rod is saying that she gave him orders to go get them pros. Defendants do not advance any independent basis on which to dismiss Jones' TVPA claims as to quorum. It is a reasonable inference that quorum violated TVPA Section 1591A1 by recruiting and enticing Jones to engage in commercial sex acts, knowing or at least acting in reckless disregard of the likelihood of coercion. Quorum may also be liable under Section 1591A2 as one who benefited from Combs' venture, notwithstanding her awareness of and participation in the venture's TVPA violations, but the court need not evaluate that secondary basis for liability at this stage. Now, what I find to be interesting is if him and her were in on it, and this is happening under the guise of music business, I don't see how RICO does not stand up. But I don't get paid to defend these things in court, so I'll move forward. Combs Global. The operative complaint does not allege that Combs Global, the corporate entity, directly enticed, recruited, or otherwise induced Jones to participate in any commercial sex acts. Liability thus depends on whether Combs Global benefited from participation in Combs' venture, notwithstanding knowledge or reckless disregard of his TVPA liable misconduct. Although the Second Circuit has not conclusively determined the meaning of participation in the TVPA, courts in this district have tended to interpret it as requiring a causal relationship between the defendant's participation in trafficking and their purported benefit. Okay. I'm going to skip past some of these examples. I'm sorry. The situation here is closer to Noble than Canosa. The operative complaint only discusses Combs Global in laundry lists alongside Combs, Love Records, Quorum, and others. The complaint fails to identify any distinct actions taken by Combs Global to either facilitate or cover up Combs' conduct, and it does not identify any funds contributed by Combs Global that Combs used to commit the alleged misconduct. The complaint further fails to even identify the business and investments that make up Combs Global's diverse portfolio. Accordingly, the allegations fail to support a reasonable inference that Combs Global benefited from any participation in a trafficking venture, and Jones' TVPA claim against Combs Global is therefore dismissed. So they will not allow the involvement of Combs Global, which is one of Diddy's businesses, to be involved, which by taking them out takes away the organized crime element, I guess, or at least the racketeering. In addition to his federal claims, Jones asserts a variety of state law tort claims based on incidents of sexual misconduct that allegedly occurred while he was living and traveling with Combs. Although defendant's misconduct allegedly occurred in at least 3 states and 1 foreign jurisdiction, no party addresses choice of law in their briefs. Applying New York choice of law rules, the court determines for now that the relevant law for each of Jones' tort claims is the law of the state where the tort occurred. Interesting. As it pertains to S.A., Jones asserts a claim for S.A., which the court construes as a claim for assault and battery based on sexual contact against Combs. Combs' only argument against this claim is that Jones fails to allege sufficient factual detail, which both provides insufficient notice of the claim and renders plaintiff's claim implausible on its face. While Jones does allege in general terms that Combs continuously touched and groped him throughout their time living and working together, Jones also alleges specific instances of unwanted sexual contact. This includes Combs drugging and sleeping with Jones at Combs' Miami home on February 2nd, 2023. Such allegations, at least some of which include specific dates and descriptions of sex acts, are sufficient to provide defendants with adequate notice. Okay? So looks like this will move forward in terms of SA. Let's see here. Jones' allegations are also sufficient to state a plausible claim under at least Florida law, which imposes civil liability for the threat of offensive sexual contact or the intentional infliction of such contact. The court thus declines to dismiss Jones' sexual assault claim as to Combs, so that will move forward. Now, as it pertains to emotional distress, Jones asserts claims for negligent and intentional infliction of emotional distress against Combs based on the same conduct underlying his SA claim. Jones fails, however, to adequately plead a required element of those torts, severe emotional distress. Regardless of which substantive state law governs Jones' claims, that element is required and must be pleaded with specificity. Yeah, I know, specifically, goddamn. They then give an example. So plaintiff offers no facts indicating what emotional distress he suffered, how long it lasted, how severe it was, and whether he sought medical treatment for the distress. So they're pointing out other examples in which the lack of information didn't help. They say while Jones includes a few additional details in his opposition to the motion to dismiss, Jones cannot amend his complaint by asserting new facts or theories for the first time in opposition to defendant's motion to dismiss. Jones' intentional and negligent infliction of emotional distress claims are therefore dismissed, so that will not move forward. Premises liability. Jones also asserts claims for premises liability against Combs based on the alleged SA committed by Jane Doe 1 and Gooding. Defendants argue, and Jones concedes, that Florida law applies to the incident involving Doe and that Virgin Islands law applies to the incident involving Gooding. In both jurisdictions, premises liability is a subspecies of negligence and thus requires a plaintiff to plead duty, breach, causation, and damages. When such dangers involve criminal acts committed by third parties, liability requires that the offender have been actually or constructively known to have a dangerous propensity. Both Florida and Virgin Island law also requires that there be a special relationship between the parties. What does that mean? For a duty to prevent third-party misconduct to arise. What you mean special relationship? Finally, both jurisdictions require that the defendant had possession or control of the premises when the alleged injury occurred. Regarding Doe, Jones alleges the assault occurred in Combs' house, meaning that Combs had both possession and control of the premises. Jones also pleads sufficient facts to support a reasonable inference of the existence of at least two special relationships, landowner-invitee and employer-employee, as Jones was working under contract for Combs at the time of the assault. And even though Jones does not allege that Doe had a known history of committing SA, he alleges that Combs witnessed Doe attempt to straddle and have sex with Jones while laughing and encouraging her to continue. So he says Diddy was watching this happen, and he was like, "Go get it," enjoying the show. Jones also alleges that Combs was aware that Doe was assaulting him in the bathroom while it happened, and that he did nothing to intervene. Again, this is where she attempted to S his D. Together, this is sufficient to permit the reasonable inference that Combs knew or should have known about her propensity to commit sexual A, and that he violated his duty to prevent her assault on Jones. Combs invokes Florida impact rule, which generally bars pure claims for emotional or mental damages unless the plaintiff sustained a physical impact from an external source. But Jones plainly alleged in impact to his body, SA. Where there is an unauthorized touching, there is no need to demonstrate physical injury. Accordingly, Jones need not plead in detail his physical or emotional injuries to survive a motion to dismiss. Regarding Cuba Gooding Jr., the situation is similar. Jones alleges that Gooding's actions should have been foreseeable to Combs, as Gooding pleaded guilty to a misdemeanor charge based on misconduct in 2022, among other publicly reported instances of similar misconduct. More importantly, however, Jones alleges that Combs intentionally left him and Gooding alone in a makeshift studio on Combs' yacht after suggesting that Gooding get to know Mr. Jones better. The fuck I need to know this nigga for? We just playing some songs, ain't we? Along with Jones' allegations that Combs was grooming him by frequently suggesting that Jones engage in man-on-man acts, this supports the plausible inference that Combs foresaw and enabled Gooding's alleged assault of Jones. Combs responds that Gooding had only been accused of assaulting women, not men, making his assault of Jones unforeseeable. But it is not implausible as a matter of law to think that someone who has assaulted members of one sex in the past is more likely to assault members of the other in the future. Combs also argues that because he chartered the yacht on which the assault occurred and was not the yacht's owner, he cannot bear premises liability. Jones acknowledges that the yacht was rented by Combs for several weeks, not owned. The court disagrees with Combs for two reasons. First, Combs cites only Florida law for his proposition, not Virgin Island law, which he concedes governed Jones' claiming concerning Cuba Gooding. Unlike Florida, the Supreme Court of the Virgin Islands has held that in all premises liability actions, the touchstone is the foreseeability of harm and not the labels attached to the plaintiff or the defendant, and has rejected the use of outdated and formalistic distinctions pertaining to ownership or possession of property or chattels. So whether it was owned or rented by Diddy is inconsequential. He was still the person in charge. Second, the case on which Combs relies concedes that a vessel charterer can bear premises liability when it holds operational control over the circumstances giving rise to the claimed injury. Okay, in Johnson, the court explained that time charterers typically delegate to vessel owners the responsibility to arrange and pay for all stowage activities, and that it would therefore be nonsensical for the charterer to owe a duty to ensure the safety of longshoremen who engage in those activities. Here, however, Jones' injury arose from Combs' decision to invite Gooding onto the yacht that Combs had rented. So for people in the future, be careful of who you invite into your premises, because if something happens, you could sustain liability, even if you're not in the room. Here, however, Jones' injury arose from Combs' decision to invite Gooding onto the yacht that Combs had rented. Because Combs held control over the circumstances that led to the alleged injury, Gooding's presence, Johnson is inapposite. Because Gooding allegedly engaged in unwanted sexual contact, Jones need not plead detailed physical or emotional damages stemming from that contact. The court therefore declines to dismiss Jones' premises liability claims, which means it will move forward. Now, breach of contract. Finally, Jones asserts breach of contract claims under Combs and Love Records for failure to compensate him for the work on the Love album. In a contract case, New York courts will normally apply the law of jurisdiction, having the greatest interest in the litigation as measured by that jurisdiction's contacts with the litigation. However, as with tort claims, the first step in any choice of law analysis for a contract claim is to determine whether there is an actual conflict. Here, defendants maintain and plaintiff concedes that there is no such conflict, so the court applies New York law based on Jones' residence in New York. Under New York's statute of frauds, any contract that cannot be performed within 1 year is unenforceable unless it is in writing. Whoa, hold on. So you've been doing all this based on promises and not actual contracts? I gotta read further because that don't sound right. This includes an indefinite agreement to pay royalties, like the alleged contract at issue here. Whoa. Under New York law, an oral agreement that is void under the statute of frauds may not be severed to save an otherwise enforceable agreement. Jones fails to respond to this argument other than by arguing that all of the songs composed by Mr. Jones were completed in less than a year. This is irrelevant. Damn, Roddy. You ain't trying to get rich. You ain't getting no contract. You produced a whole album with no paperwork. What happened to the promise of $20K per song? What happened to getting four points on the master? What happened to your publishing agreement? None of this was written in paper? This is irrelevant, as it is defendant's portion of the contract that could not be completed within a year, not Jones' portion. Because the oral agreement is subject to the statute of frauds, Jones' contract claims are dismissed. So you're never going to get paid for your contribution to the album. God damn. That might have been your best bet, was to try to get that at minimum. Now, other defendants. On September 9th, 2024, Jones filed a letter with the court requesting an extension of time to serve defendants Justin and Gooding. I believe Justin would be Justin Combs. The court granted the request and directed Jones to serve those defendants by November 8th, 2024. Jones has not since notified the court that service has been completed. So you tried to put Justin Combs and Cuba Gooding Jr. in this bitch, and you never served them? Huh? Accordingly, Jones is directed to file a letter with the court explaining the status of service as to Justin and Gooden within 2 weeks of the date of this opinion. Should Jones fail to do so, the claims against those defendants may be dismissed for insufficient service or failure to prosecute. Come on, boy. I mean, Justin allegedly took part in a shooting within your circumference. You didn't serve him the paperwork? Cuba Gooding allegedly touched on you, and you ain't served him the paperwork? Wow. Jones has also not yet served Jane Doe 1, a.k.a. Young Miami's cousin, but has provided no explanation for his failure to do so. She the one that put hands and tried to put a mouth on you. You ain't served her neither? But it could also be because he doesn't know their address to send it to. That could be the problem. I don't know. Just saying. The court therefore dismisses Jones' claims against Jane Doe 1. Damn. Well, that's out. You can't talk about that no more. Which also means that some of the fervor in the sexual claims that they are allowing to move forward are going to be moved out again, because you're not going to be able to make reference to Jane Doe 1. Damn. Conclusion. For the foregoing reasons, the Combs defendant's motion to dismiss is granted in part and denied in part. The motion is granted as to Jones' RICO claims, negligent and intentional infliction of emotional distress claims, and contract claims. The motion is also granted as to Jones' TVPA claims against Combs Global. The motion is otherwise denied. Jones shall file a letter within 2 weeks of the entry of this opinion explaining the status of service as to Justin Combs and Cuba Gooding Jr. Jones' claims are dismissed as to John and Jane Doe's 1 through 10 and ABC Corporation's 1 through 10. Defendants who have been served shall file an answer to the surviving claims within 14 days after the date of this opinion. The clerk of court is directed to close the motions at docket numbers 40, 60, and 71. So ordered, the judge, J. Paul Etkin. So the entire RICO goes down, which means a bunch of these John and Jane Does have been absolved. And the companies, in most cases, have also been absolved. So now this is really just against Diddy, Christina Coram, and if he can get his fucking paperwork together, it'll be Justin Combs and Cuba Gooding Jr. If not, Justin Combs and Cuba Gooding Jr. will also be dismissed. Nigga got about 2 weeks to get that together. Crazy work. So yeah, Lil Rod, the work is on you, homie. You got to get your shit together. You got to get your paperwork together. You got to get your motherfucking lawyer together. Because why has he not been answering towards Diddy and his lawyers' rebuttals? If they're rebuttaling against your complaint, why are y'all not answering and trying to enforce why your claims are valid? You're starting to look a little bit funny in the light. You're starting to look like a $3 bill out there, bitch, sir. And you told us all about this fucking breach of contract, and the only contract you got is word of mouth. You're starting to look like an $8 bill, my nigga. And you ain't even served half of your defendants that you claim tried to touch and kiss and rub upon you. You're starting to look like a $12 bill, my nigga. But that's just my 2 cents. Y'all let me know what you think of all this down below in the comments. Be sure to like and share this video. If this is your first time to see me on YouTube, go ahead and subscribe to the channel, become an insider. If you notice any difference in the camera, my other camera decided to wig out on me, so we had to switch it up real quick. But I'm going to catch y'all on the next one. Much love and respect, y'all. Peace. Yeah.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda, we hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer, we come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some batteries. Stand for my honor, but I know calm and stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.